Hello viewers, and welcome to our video presentation entitled Estate Settlement in Connecticut. My name is Richard Land and I'm a member of the law firm known as Chipman Mizuko Emerson in Danbury, Connecticut. So let's begin. When you prepare a will, you're leaving instructions for the executor to carry out. It's important that the executor understand what the job of being an executor is all about, what needs to be done, and how the executor is supposed to do it. The purpose of this video is to provide executors and administrators with basic information they need in order to do the job. So let's talk about what a typical executor will face. Take a moment to think about your own life and your assets. There are many things that no one else in the world knows about. You may have work in process, bills to pay, loans to friends and family, loans from friends, and unique assets like collections and weapons, and the investments that you look after. To everyone except you, this would be a difficult puzzle to figure out, and then you die. And you leave a lot of different people who are interested in what you left behind. It's not just surviving family members who are interested, it's everyone who had a financial interest in you and your assets. There are creditors, including family loans, business partners, any business deals you're working on, and of course, there's the IRS and the Connecticut Department of Revenue Services for income taxes and other types of taxes, including estate and inheritance taxes. Your executor must consider all of this. That's what estate settlement is all about. It's the process of fixing or resolving conclusively the rights of interested parties in the estate. Let's start by defining what an estate is. Before we can do a good job discussing estate settlement, we need to know the meaning of the word estate. The word means different things to different people depending on the context. For the purposes of this presentation, the focus will be on the probate assets. What do I mean by probate assets? When you pass away, you may leave joint property with right of survivorship or life insurance contracts or other assets where you can actually name a beneficiary. These are assets that already have a beneficiary designated in some way. Compare such assets to assets that are in your sole name that have no beneficiary designated. For example, you may own shares of stock that are just in your name, or a bank account that's just in your name without any beneficiary named at all, or real estate that's just in your name. The first type of asset I mentioned, which is the non-probate property, includes the joint account with right of survivorship and the life insurance policy with a beneficiary designation. That's what we mean by non-probate property. The second type of property is the probate property, the property in your sole name without a beneficiary designation. That's the property that your will controls, and that's what we're talking about when we talk about estate settlement. So the focus is on the probate property, and the executor's job is to fix or resolve conclusively the rights of interested parties in the probate property of the decedent. That does not mean an executor can ignore the non-probate property, primarily because the non-probate property is very important when it comes to tax matters, and the executor's powers and responsibilities extend to those types of tax matters. We'll get into many of the tax issues later in the presentation. Keep in mind that in this video, I'm not going to be covering how small estates are handled, and in Connecticut, that means an estate which does not include any real estate and whose assets have a value less than $40,000. There's a special procedure for small estates. This presentation deals with the estates which do not fit within the definition of a small estate. The probate process starts with an application to the probate court. Usually the proposed executor or administrator is the person who makes the application. Why is an application necessary? When you make the application, what are you asking the court to do? One of the main reasons is access. When you pass away, the bank where you have your solely owned account or the broker where you have your solely owned investment account needs to know who has authority to take possession of the assets. The probate court is the agency we have for granting someone, that's your executor or administrator, the authority to take possession of your probate assets. So how does that work? First, who should be appointed as the executor or administrator? If there's no last will and testament that nominates the executor, Connecticut statutes list the surviving relatives who the court first considers for the job in an order of preference. So you can see that if you're married and died without a will, your spouse, if willing, would be appointed administrator. If you're not married, or your spouse is not willing to serve, the court would go down the list of closest relatives. The statutes are designed to prefer your closest surviving relatives. If there is a will, usually the person named in the will to be the executor makes the application, and unless there are unusual circumstances, the person nominated in the will to be the executor will be appointed by the probate court. Let's take a look at the Connecticut application. After you get by the instructions, in the middle of the page, you'll see spaces where you put the basic information. It's the decedent's name, the place of residence, and other basic information. Then we go on and we see the important part where you give the court information about your heirs, beneficiaries, and sometimes trustees. People get mixed up by the term heir. Your heirs are not the beneficiaries of your will. No, instead, they're the people who would inherit if there were no will. So the will might disinherit the heirs. The heirs can be adversely affected by the terms of the will. The heirs, therefore, are likely to be very interested in what the will says or whether it is effective or valid. In other words, they're interested parties who are entitled to know about the application. The court, therefore, needs to know who the heirs are and where they can be reached. Each heir will be given a notice of the application and will be given an opportunity to contest the will or the appointment of the executor. Typically, during the beginning stages of the probate process, if an heir complains, the complaining party will be trying to prove either that the person who made the will, we refer to that person as the testator, was unduly influenced by one of the beneficiaries, or that the testator had insufficient capacity to make a will, or the complaining party might be making a claim that the person nominated to serve as executor or administrator is unfit for the job. In any event, the heirs are entitled to make their claims or make their case, so the court needs to know who they are, and their information goes here in the application. The application then asks for names and contact information for the beneficiaries under the will, and then it asks some specific questions, including whether there were any children born to the testator after the will was signed, or whether the testator got married after the will was signed or got divorced after the will was signed, whether any children of the testator were children from a previous marriage, whether the decedent owned real estate, and whether the decedent or the decedent's spouse or children received any financial aid from the state. All of these questions are relevant to how the terms of the will might be applied or how the executor or the administrator does his or her job. Finally, the application asks the court to admit the will to probate. In other words, it is asking the court to make a finding that this truly was the last will and testament of the testator, and it asks the court to issue letters testamentary. In Connecticut, what the executor will actually get is a fiduciary certificate, which is similar to letters testamentary. The fiduciary certificate will be evidence to the bankers, the brokers, and any other interested party that the person who was nominated in the will to be executor was actually appointed by the court to serve as executor. So that's what the application's all about. Then at the end of the application is a spot where the executor signs and says that if I'm appointed by the court as executor, I agree to serve. Notice that the application does not refer to a bond, but bond may be important, so I'll mention it briefly. What is a bond? The bond is really merely a promise by the executor or the administrator that he or she will faithfully perform the duties involved in settling the estate. If there is no will, the court will require that the promise be secured by a surety company. That's through an insurance contract, which will make the estate whole if the administrator breaches his duties, resulting in damage to the estate. If there is a will, it will usually waive a surety bond, and normally, in that case, none will be required by the court. So the need for a bond is something that should be considered as part of the probate application process. So you go through the process of making the application and presenting it to the court. What happens next? One of the functions of the probate court is to provide a forum where the interests of interested parties can be protected. When we talk about interested parties, we typically mean creditors, tax authorities, and beneficiaries. The probate process requires notice to these interested parties, and the executor may have specific duties as a fiduciary to sort out the claims of the interested parties. These duties include the duties of loyalty, diligence, and impartiality, which we'll talk about more completely later. It's the attorney's job, when representing the executor, to provide the type of advice the executor needs to sort out the competing claims of the interested parties and to properly complete the administration of the estate. It's important for the executor or administrator to know about how the duties apply to him or her as early as possible after the decedent's death. One of the first things we provide for the executor or administrator is a letter. We call it the estate settlement letter, to help the executor understand the scope of the job and the special issues the executor might face. We'll talk more about the estate settlement letter in part 2 of this video. Anyway, as I mentioned earlier, the creditors of the decedent are interested parties, and one of the first things the Connecticut probate courts do is publish a notice in the local newspaper announcing that the executor or administrator has been appointed and inviting the creditors to make their claims by contacting the executor or the administrator. Creditors have 150 days to present their claims from the date the executor or administrator is appointed. There is a procedure available to the executor to shorten the 150-day period, but in effect what the 150-day period means is that in Connecticut it's difficult for an executor or an administrator to finish estate settlement before 150 days or 5 months goes by. So let's recap. Let's say your friend or relative has passed away and you've been appointed executor of his will, or if there is no will, you've been appointed administrator. You've gone through the probate application process that we just described, and the court has appointed you as the executor or administrator, and the court has published the notice to the creditors in the newspaper. Now is when your job really starts. One of the first things you should do is to try to locate and take possession and protect all the probate assets. So you need to go through all the decedent's possessions, records, tax returns, and mail, looking for clues about the assets. Connecticut statutes require you to file with the probate court a list of the assets within 2 months after the time you're appointed executor or administrator. Extensions, though, are frequently granted. This list is called the inventory, and here's a sample of what a properly prepared inventory looks like. The values you see here are the date of death values. Keep in mind that one important function of the inventory is to fix your personal responsibilities as executor or administrator. The inventory is the starting point. As executor or administrator, you should be able to report to each beneficiary and to the probate court how you handled each asset on the list and all the income that is derived from each asset. So that's the end of part 1 of this video. In part 2, we'll explain the type of information that we like to include in the estate settlement letter that we prepare for an executor and other aspects and phases of estate settlement. Thank you for viewing.